Okay, welcome to today's EPA Region 5's Advanced Worker Protection Standard Inspector Training webinar. I am Donald Baumgartner of EPA Region 5 Pesticide Section, and I have the pleasure of being your moderator and one of several trainers. Today's training is intended for state lead agency and tribal pesticide inspectors who conduct WPS inspections. This training may also benefit state tribal case developers and supervisors. This webinar qualifies as refresher training for federally credentialed inspectors. Participants must complete two parts, the first given today, and the second part to be aired on May 31st, in order to receive full credit towards your federal credentials annual refresher training requirements. The two webinars are not identical in coverage. This webinar is being recorded and will be later posted off the wiki website for viewing again by you. The open Q&A session at the end will not be recorded though. Inspectors who may have missed this webinar may also receive credit for viewing this webinar later off the wiki site. The complete two-part advanced WPS training will also be made available later through the wiki website for all other state and EPA regional inspectors nationwide. Today's webinar is hosted by the EPA Center for IPM. We thank them for working with us on this training. Okay, the toggle between the maximize and standard view of the presentation, click on the yellow arrow. If you see the yellow arrow there. If you're having technical difficulties, press and raise your hand icon. That's the blue arrow, and the staff would do the best to address your questions. Normally, we'd be able to download the PDF version of the presentation, but there were difficulties uploading it this morning. So the PDF of this presentation will be emailed individually to every registered and signed on trainer. If you fail to see the icons on your screen, you may have to reload this link in either Firefox or Chrome if you don't see these icons. During the presentation, you will also be able to pose questions using the question box, and that's shown at the red arrow. However, your questions will not be answered until the very end of today's webinar during the allotted time for the Q&As. You also may not be able to get to all your questions today, so please identify your state at the top of the question as you type them in. Next slide. Please be reminded that this training is not intended to cover all the basic requirements and protections afforded to agricultural workers and handlers under the WPS. The limited time of this webinar format does not allow for extensive coverage that would normally be covered over multiple days in formal BPA PERT courses. We have condensed the WPS regulation into particular focus areas that we think may be of most interest to you, as well as areas of the regulation which have shown from past inspections to have the most non-compliance. Other focus areas are where states have expressed problems with the WPS. Built into this webinar is ample time as well at the end for your questions. We will also try to address questions already submitted to us from Michigan and Wisconsin, as we had requested previously. Questions will only be answered in the last 30 minutes of the webinar. Please do enter your questions in writing in the question box on your screen. You can do so throughout the webinar for later answers, or enter your questions at the very end during the Q&A time. Please try to be brief, concise, and to the point in your questions. We may not be able to answer all your questions during this webinar, but the question will be captured nonetheless for later consideration. The telephone line will not be open for your verbal questions due to past experience with background noises. Again, the Q&A session will not be recorded. The Part 2 training webinar will be aired May 31st, at the same time as this webinar. EPA Region 5 will send out another formal announcement and registration link next week. Please be aware that there will be a pause delay in the slide advancement as we switch to speakers. Please be patient when we switch to presenters as we await their ability to control the slides. As far as the presenters, I am Donald Baumgartner of the EPA Region 5 Pesticide Section. I provide technical assistance to the states, industry, citizens throughout the Region 5 area, also in worker protection standards, certification and training, urban structural pest control, public health, structural pesticides, mosquito control and Zika, ticks, bedbug management, and general regulations. Another presenter is Richard Pont from the EPA Certification and Worker Protection Branch. He's an environmental protection specialist in the EPA Certifications and Worker Protection Branch, and also a senior advisor for the EPA Worker Safety Program. He assists EPA efforts to implement the revised WPS and the applicator certification rules. Richard has over 30 years of experience working in pesticide regulatory programs, including over 27 years working in the Region 4 office. Okay, Nancy Fitz, although not a speaker today, she will be involved heavily in part 2 of the webinar, so we're going to kind of pass her up right now. And then another presenter, trainer is Carol Galloway of EPA Office of Compliance. She is involved with the Work Protection Standard and Certification and Training Coordinator, as well as the National Coordinator for Concentrated Animal Feeding Operations. She also supports the EPA's Kansas City-based National Ag Center, where she is involved with EPA issues related to agriculture. As far as the agenda for today's webinar, here's an outline. So after I finish up the logistics and everything, introductions, we're going to have Carol coming in talking about the inspection manual. Then Richard will follow up talking about WPS scope and applicability and exceptions. I will then come in with hazard communication, central display notification. And then Carol will come back again with mitigation, decon, eyewash, emergency assistance. I will follow up with training requirements. And then Richard will close their formal presentation talking about employer responsibilities. And as I said, the last half hour is delegated to questions and answers. All right, I just want to give you a teaser for part 2. This will be aired on May 31st. It'd be very heavy on PPE requirements and PPE exceptions, as well as the respirators information and fit testing. And then also be very heavy on the AEZ, as well as off-property scenarios. And then we're going to wrap up part 2 at the end with inspector materials and employer materials that are available for WPS compliance and inspections. Certificate of participation will be provided after the conclusion of today's webinar through a web link that will be provided to you within a day, probably within a couple hours of the conclusion of this webinar. We recommend that you print out the training certificate as your proof of attendance, retain a copy for your records, and perhaps also provide a copy to your supervisor and the EPA Region 5 technical contact. If you do not receive an email in a day or so from this webinar, or have difficulty opening the certificate, please do contact me, and I will provide my contact information near the conclusion of today's webinar. Now, with all the preliminaries over, I'd like to introduce Carol, the first speaker, Carol Galloway.
Great, thanks, Don. Good morning. Well, before we jump into talking about the Worker Protection Standard, I'd like to talk a little bit about inspections in general. As you folks, I'm sure already know, understanding the regulations is critical, but so is being proficient in the inspection process. So we're going to talk about the role of the inspector, the importance of collecting solid evidence, and then we'll talk about resources that are available to inspectors to help make your job a little easier. The inspector is really part of the enforcement team, even if the lawyers are in a separate office or even in another city. You, the inspector, are really critical to ensuring compliance with the Worker Protection Standard. You're an advisor to the team. And the lawyers should explain to you, what they need to bring an enforcement action, and you need to work with them to explain, what's feasible and what's not. There should be good two-way communication there. You may be called on as a fact witness or an expert witness if a case is litigated, and you're the author of the all-important inspection report that forms the basis for the whole enforcement action. So the inspection is all about evidence. You have to establish the facts through evidence, and for a judge to accept it, it's got to be on point, it's got to be relevant, and collected using the proper procedures, like following the chain of custody procedures if you collect samples. You have to have both. You've got to have the procedures really lay the foundation for the evidence that you collect. So you have to conduct the inspection correctly, and you also have to collect the evidence that's needed to support the case. And one isn't really any good without the other one. There's no point in collecting evidence if you didn't use the correct inspection procedures. And following the procedures doesn't do you much good if you didn't collect the evidence that you need. So now getting into the Worker Protection Standard, as you folks probably already know, compliance with most of the 2015 regs was required by January 2nd in 2017, and then compliance with the rest of the requirements, with one exception, was required a year later on January 2nd, 2018. And we'll talk about this more later, but the only element where compliance isn't required right now is the requirement to include new content for the worker and handler training. That's fairly straightforward. However, last December, EPA announced it was beginning a rulemaking effort to take a second look at 3 elements of the regs. The idea of establishing the minimum age of 18 for handlers and early entry workers, the ability to designate a representative to request information for workers and handlers, and the application exclusion zone concept. As we know, EPA's regulatory processes can take a while, and this effort may or may not result in any actual changes to the regs. So in the meantime, compliance is required with all of the regs, with that one exception, and will be required until an EPA action changing them is finalized and is made effective. To help EPA and states and tribes conduct WPS inspections, EPA developed the WPS Inspection Manual. EPA inspectors and anyone conducting WPS inspections using a federal credential needs to follow the manual. But states and tribes may also want to have this manual as a reference, and it's available on EPA's website at the address shown. The manual really focuses on aspects of FIFRA inspections that are specific to the Worker Protection Standard. And it's a supplement to the overall EPA FIFRA inspection manual that was released in 2013. So for basic FIFRA inspection information, you can refer to the FIFRA inspection manual. And this slide shows you the chapters of the 2014 manual. It addresses general issues like gaining entry to a facility, health and safety considerations, and basic FIFRA policies and strategies. So it's a useful reference. It's undergoing some review right now, and the revised version may look a little different, may have slightly different chapter headings. We'll certainly let everyone know when that revised manual is released. So the WPS inspection manual is laid out in the same order as you would conduct a typical inspection, beginning with the opening conference and then going into reviewing product labels and now other records that should be available, records of the applications, copies of the safety data sheets, training records, and if respirators are used, there should be respirator records. Then, of course, there's the site visit, including the interviews of employers, supervisors, workers, and handlers. Finally, there's the exit conference and post-inspection activities like writing the report. And finally, attached to the inspection manual are a number of appendices that may be helpful for you. There are sample checklists. There's one for ag establishments, another for commercial pesticide handler establishments, and one for owners of ag establishments and their immediate families. There's more information on the OSHA regs that were adopted into the Worker Protection Standard, and there's the interpretive policy statement on the application exclusion zone. So it's handy to have those items readily available. Okay, we are updating the inspection checklists that are attached to the manual, and this shows some of the new changes. These will be available online soon. These we're including references to not only the regulations, but references to the pages of the How to Comply manual where these areas are discussed. And it will also be available as a fillable PDF. So you can load this onto a tablet and fill it out as you go through the inspection, which may be helpful. We can also make these checklists available as files that you can modify for your individual state if you want to tailor them. And if you want a modifiable version, you can contact me or Donald or your regional contacts. Okay, looping back to the inspection process, to establish the groundwork for a WPS case, you need to be able to tell your inspection story. You need to establish where you went, who you talked to, what you asked, what they answered. You need to document all of that, including what you didn't see, what was missing, what you should have seen. It's good to ask about things you can't see. Even if there's no application going on, you can ask about the application exclusion zone. Were there any people around when you conducted the application? Where were they standing when you saw them? What did you do in response? You can document all of those answers, and then if possible, verify those answers by asking the same question to different people. Checklists are very useful tools, so you don't forget anything, but you need to remember that you've got to include sufficient documentation to establish the facts and tell the whole story. Finally, I wanted to mention that there is WPS inspection information available online on EPA's ECHO system, Enforcement and Compliance History Online. You can see here some of the information you can get on the dashboard. Here are the top types of violations found across the country by states and tribes. And this data is provided or based on the 5,700 reporting forms that are submitted to EPA under the cooperative agreements. And the 5,700 forms don't reflect the new types of violations related to the 2015 regs. So violations of the respirator requirements aren't captured, minimum age isn't captured, but EPA is planning to update the 5,700 form in FY19. In case you couldn't see the data in that last slide, the top 5 most frequent WPS violations between 2012 and 2016 are central posting, safety training, notification, decontamination supplies, and personal protective equipment violations. I'd like to wrap up this session with a reminder that the Office of Compliance at EPA wants to support high-quality state WPS inspections. To support you, please let us know what tools are working and what tools you would like to have. And if you have comments and questions, be sure to contact your regional WPS contact. We seriously do appreciate hearing from you through the regions and through APCO. So let us know about issues you're having with inspections. And that concludes this session, and I'll hand it back to Donald.
Thank you very much, Carol. Next on the agenda is Richard Pont, who's going to address WPS scope, applicability definitions, and early entry exceptions and exemptions. So, Richard, you can take that away.
All right. Good morning, everybody, and thank you again for participating. We're going to start the WPS content by looking at the scope, applicability, and definitions and early entry exceptions and exemptions. Before we start talking about some of what the exceptions are, I just want to give everybody a brief refresher and cover some of the basic foundational principles in terms of the applicability of the WPS. With the 2015 revisions, one of the changes that was made was that rather than defining the individual establishments that are covered, such as farms, forests, nurseries, and greenhouses, we essentially just defined an agricultural establishment now, so that farms, forests, nurseries, and greenhouses are all considered agricultural establishments, but we don't define them. One of the issues with that is that people try to find ways to decide that they weren't either a farm, forest, or nursery because of the definition. So that was one of the reasons to sort of broaden the approach. The other is that greenhouses have evolved so much since the original WPS that they no longer really encompassed the various types of production that were occurring in what used to be greenhouses. Now we have a whole scope of different types of indoor production that sometimes are in greenhouses, but are inside in completely enclosed structure like grow houses and things. So that's why another change in the WPS in terms of defining who's in and who's out was to change definition of, or change the sort of scope of using greenhouse and instead calling it indoor production. And so now there's 2 types of production covered: indoor and outdoor production. Most all farms and forests and nurseries would fall into outdoor production, but there are still technically farms that can be indoor farms. things that are just, farms grown in greenhouses and things like that. So that was one of the key changes. The other is that, again, the definitions that bring things into scope were changed, that now the three key definitions that sort of define the scope of the WPS are agricultural plant and agricultural establishment and employ, with agricultural establishment being the one that basically defines, essentially any establishment that is growing a plant other than those that are covered by exceptions are potentially going to be covered by the WPS. So essentially it comes down to is if you are growing plants and you are using a WPS pesticide and your type of growth covers one of the things covered by the WPS, then its chances are that establishment will be considered an agricultural establishment. The other thing is it's not just growing plants. The way the agricultural plant is defined in the WPS, it is not just growing an agricultural plant. By the definition of an agricultural plant, it includes not only growing plants, but maintaining plants. And so that brings in things like retail nurseries that maintain plants, as well as conducting research on plants. And so the definition of agricultural plant is where we define that people maintaining plants or conducting research are also covered as ag establishments and not just those growing. And the last thing about scope and applicability that is important to bring up is that you don't necessarily have to actually be using a pesticide to be covered by the WPS. There are those people that provide crop advising services that never actually use a pesticide, but do fall under the scope of the WPS as crop advisors. As well as other entities that are covered are people that provide pesticide application services, and those are the commercial pesticide handling employers. All right, so as I was mentioning then, in talking about what's covered, we mentioned all the types of establishments that do fall under the WPS. It's important to note, as I said, that the other key definition is employ. It used to be that under the old WPS, employing somebody was one of the key things that brought you into the WPS, but it is important to note that that's no longer the case. Even owners of establishments, the immediate family establishments, are covered by some of the provisions of the WPS now. So even a family establishment that doesn't employ any workers or handlers outside of their family are still covered by some aspects of the WPS. And we'll talk more about that when we get into the immediate family exemption a little later. But so now we'll talk about these exceptions, because as I said, essentially, if you are growing an agricultural plant on establishment, you are probably covered by the WPS, except for those that the rules specifically excluded because of reasons that found that that type of plant production shouldn't fall under the WPS because of the nature of it, or wasn't the type of production we wanted to cover. And that is certain government-sponsored public pest control programs. Those are things like wide area pest control programs where the owner of an agricultural establishment would have no knowledge. So that would be things like mosquito control programs or wide area quarantine programs like medfly eradication programs, things like that. But the boll weevil eradication program is one that people often point to that is not covered by this exception, and that's because that program specifically contracts with individual growers and arranges for the applications. And so in those situations, the grower is intimately involved in the application, has knowledge of it, can meet all the posting requirements and things that they can't do in this situation where it's just an application that is made overnight to their property by some mosquito control or something, where nobody is informed of the application, what products are used, and the types of things that an employer would need to be able to carry out WPS responsibilities. Other types of things not covered: home fruit and vegetable gardens and home greenhouses. So essentially, anyone that is just growing things for home use and not doing it any type of business or any type of entrepreneurial thing, those aren't covered. Permanent ornamental plantings that are only for aesthetic purposes. So anything planted into permanent parks, permanent gardens that are only really just to display the ornamentals for no other reason, except for just having a park or things that visit. Those type of plantings aren't covered. We did have a recent example, though, where a university actually has an area where they plant ornamental plants, but they do it because they're researching sort of the long-term survivability and utility of those ornamental plants in certain landscape environments in the state. So they're essentially testing those. They're conducting pesticide research on that. And it's not a public park. It's an area where they plant those ornamental plants specifically to conduct research on the suitability of those plants for the climate and things like that. So because that's research they're conducting and they're using pesticides in that research, then that brings those ornamental plantings into scope of the WPS, because now it's research and not just an ornamental planting. So those are the types of things you have to consider. Another thing that's not covered is control of vertebrate pests. Originally, we thought about taking this out of the WPS and covering certain types of vertebrate pest control, but we were convinced by both internal scientists within EPA that register these products that the nature of their use and the fact that most of them are put in tamper-proof break boxes and things like that, felt they should continue to be, so we are maintaining the exception for control of vertebrate pests. We also don't cover pesticides applied as attractants or repellents and traps, and that's when it's part of like a regulatory control program or anything like that. So when people are doing things like medfly trapping and those sorts of things, both USDA and state regulatory people, those things are not covered. Post-harvest applications to the harvested plants or plant products are not covered. So we do not cover anything once the plant has been harvested and removed from the field. And that's important because while a plant is still in the field, even if it is at a point where, say, the production is done and you're just sort of saying applying something to burn down that crop, that is still a covered application. It's not considered harvested until the plant matter is removed from the field and either packed into boxes or something like that, or moved to packing sheds. So again, post-harvest uses aren't included, so that means all sorts of packing shed applications or storage, post-harvest storage commodity applications, those are all not covered. We do not cover, the only research we don't cover is unregistered pesticides, and that's because unregistered pesticides don't have a FIFRA Section 3 labeling and therefore don't have the WPS reference, and that's why they're not covered. We don't cover pasture and rangeland where the forage will not be harvested for hay. So anywhere where all it is just open rangeland and they aren't cutting any of that pasture harvest or rangeland for hay, that's not a covered use. And then lastly, livestock pest control, structural pest control are not covered, and then vegetation control in non-crop areas. This is another area we recently had some questions out and wanted to make sure that you understood that the exception is only for vegetation control in non-crop areas. In other words, like ditch bank weed control, other non-crop area weed control. But if you are controlling weeds in crop area like fallow land or pre-plant herbicide applications, those are all covered. Don will talk a little bit about that in his Q's and A's. Another important thing to point out about this is that if you are controlling insects or pests in those non-crop areas, those are covered applications, because generally you're trying to control those insect or pathogen pests to prevent them from infecting nearby crop areas. So the only thing that is accepted is vegetation control in those things, and not other types of pesticide control in non-crop area. So now we've covered essentially all the exceptions that potentially take somebody out of scope. We'll talk about the facilities that are covered. And first and foremost, I just want to mention then that all the typical things that are covered are your traditional farms, your traditional nurseries, greenhouses, grow houses, mushroom farms. Those type of things are all traditional farms that are covered. Some of the things we're going to talk about now are those things that qualify as agricultural establishments under the rule because they meet the definition, but that some people might not have traditionally thought of as agricultural establishments. And they include things like dairy farms that produce hay for cattle. Even though WPS contains an exemption for livestock pest control, that's only for pesticides used either directly on the cattle or premises or things like that. But if somebody is deciding to grow hay for that dairy farm, then they are essentially have become a farm because they are growing an agricultural plant, and part of that dairy farm is also a traditional crop producing farm. Golf course establishments that also produce sod or ornamentals for transplant. Again, the golf course itself isn't covered if all they do is make applications to the golf course area or the ornamentals surrounding the golf course. Those aren't covered. But if that golf course decides that it wants to produce, in a greenhouse or somewhere else on the establishment, nursery plants or sod solely for use for transplanting into the golf course part of the establishment, then they basically created a nursery on that golf course establishment. And again, so they're running two types of covered establishments there, a nursery and sod farm that's covered by the WPS, and the golf course that isn't. Similar to that, park or municipal garden operations that also produce their ornamentals for their gardens in nurseries or greenhouses in some other part of the establishment, they become covered again because they're essentially operating an agricultural establishment on the other part of the non-covered park or garden. The same concept applies to theme park operations. Big establishments like Disney World, Universal Studios, Biltmore Estates and Gardens. There's several others like this. Big giant hotel complex sometimes, or entertainment operations will often have their own nursery or greenhouse site so that they can avoid having to buy those nursery and ornamental plants on the open market, and they produce themselves just like any traditional nursery or greenhouse, and thereby the persons working in those receive the same types of pesticide exposure as anyone working in a traditional greenhouse, and that's why those are covered. And then going on, another type of set of establishments where we might not necessarily think of agricultural establishments are prison farms that oftentimes have a farm on their establishment. Because the definition of employee in the WPS used to be that anybody that worked on that type of farm might have been covered even if they weren't paid, but now the rule specifically does have a provision that says in order for somebody to be considered employed and covered by the WPS, they have to be paid a wage or salary or some sort of monetary compensation. So where prison farms are getting some sort of compensation in the forms of, it can be sometimes as little as, several cents a day for working, but that still can be considered compensation. If they are receiving, cigarettes, any type of monetary thing where that could be valued. But if all they are given is just, sort of, maybe a good behavior compensation or things like that, even though some people might consider that, time off would be of much more value. It isn't something that can be exchanged, monetary, like on an open market. So people that are just given, incentives by, hey, if you work, 6 months on the farm, you'll be given off a month off your time for good behavior. That's not considered monetary compensation. Those prisoners aren't considered covered by the WPS then. Educational farms where students might be paid to help as workers, or in the sense of like university extension farms, which is down below. If those students are paid any type of compensation, either graduate assistantships or other type of wage, they are covered. But if those students are just volunteer students that work either in a classroom, and so the only thing they're receiving is a grade, and their time is coming out of their classroom participation, but they don't receive any wage, those students are not covered. So again, students that get paid, graduate assistants, those types are covered. If they don't receive a wage but strictly volunteer as part of classroom work, that is not covered. Retail nurseries and garden centers where nursery stock is maintained. This is your Home Depots, your Lowe's, retail nurseries. If they decide to maintain those plants and use a WPS covered pesticide to maintain them while they're in the retail center, they are covered by the WPS. University extension research facilities, research farms, again, anywhere where they're doing research on agricultural plants, those are covered. And then lastly, one that has come is that pine straw harvesting operations in forest. We already know that most forest operations and timber production and timber products are covered, but pine straw, because it is something, again, until that pine straw, if they go in and apply a herbicide to the forest floor so that they can go in and clean up the pine straw easier, that's a covered application. Until that pine straw is baled up and removed from the forest floor, it would be considered an agricultural forest timber commodity. Next slide. So that covers essentially the types of establishments that aren't covered through exceptions, and then the types of establishments that are covered through normally you wouldn't think of. Now we're going to talk a little bit about the exceptions and exemptions. The first are the early entry exceptions, and we just want to point out again that in the WPS, there is an exception that allows people to go in during the REI, but those exceptions are fairly restricted and they have a lot of conditions on them, so that there should not be a lot of situations where people are allowed to go in into an early entry area and conduct work. But those that where they are is during the exceptions for irrigation. You are allowed to go in and do certain irrigation activities, as well as also there's one for limited contact. So those do allow you to go in and actually do a certain type of work. The reason they are not, that you can do those is because, we'll talk about a little later, but moving irrigation equipment is not considered hand labor. So that is one of the things that you can do during an REI that doesn't trigger the hand labor provision of not being able to do hand labor. All the other things you can do during the REI must be non-hand labor activities, which, anything that would be considered working with the crop, harvesting, hoeing, weeding, things like that, are the hand labor things are excluded. The things that you can do would be things like working with equipment in that area, fixing equipment, doing anything that allows you to, make repairs to a greenhouse, go in and repair irrigation lines, things like that. The only time that you can do an actual hand labor activity is during the agricultural emergency exception, and that's because they're allowed to go in and do things to prevent an agricultural emergency from happening. So that's the one exception that during early entry they can actually go in and do some sort of hand labor. The one other key is that both the limited contact in the irrigation exception, because they are allowed to be used and you can go in and have substantial contact, those cannot be taken advantage of if a double notification product was used. And a double notification product is one that requires, you'll see it on the label, it requires both oral notification and posting, and it would have a specific provision listed on it that said double notification is required. If that's on the label, then those products could not be used for limited contact and irrigation. And the same thing, if a product with double notification is used for the ag emergency, then it limits the amount of time that you can be in that field to take advantage of the exception to alleviate the emergency. It goes from 8 hours and 24 hours down to 4 hours if they use a double notification product. So that's sort of a summary of the early entry exceptions. Next slide. The other key exemption we want to talk about here, we'll talk about two. The first is the owner and immediate family exemption. And on the owner immediate family exemption, there were some key changes with the rule that affected the scope of this that we want to talk about. And the first is that under the previous rule, in order for a establishment to qualify for the immediate family, it had to be wholly owned, meaning that all of the owners of that farm all had to be related by the immediate family relationship. And if any of them weren't, then no one in the establishment qualified and none of the owners qualified for that exemption. With the new rule, that changed, and now the rule just basically says as long as the farm is majority owned, that means greater than 50% is owned by people that are immediate family members, then not only does the immediate family owners qualify, but the non-immediate owner and his family as well. And so essentially what that means is that any farm that is solely owned just by a single individual is automatically going to qualify. Any farm that is more than 50% owned by people that have the immediate family relationship, either their brothers, their sisters, their husband or wife, father, daughter, those types of things, those would all qualify. As long as they said 50% of those are immediate family, even the owners that are not part of the 50% family ownership would still qualify. So for instance, if my brother and I own a farm and we own 51% and Don Baumgartner owns the other 49. Because 51% is family owned by immediate family members, my brother and I, the entire establishment qualifies, and even Don and his family qualify for the exemption then. So that's how the majority ownership works. And obviously this then increases the number of establishments that would qualify for the exemption. And also because we expanded the definition of immediate family, more establishments already qualify by that means, because we've expanded the number of relationships that are covered by the immediate family. Next slide. One of the most important things to point about immediate family exemption is that the exemption only applies to the owner and the immediate family members. So if somebody that has an establishment covered by the owner immediate family, but they hire a non-family member to work on that establishment, those non-family people must receive all of the applicable protections required by the rule for those people that aren't family members. Next slide. Just some then key points to remind about the family exemption. There is no exemption for the family farm. It's not the actual farm that exempt. It is only the owner and the immediate family members that qualify. So again, not the establishment that exempt. It is just the owner and immediate family members that don't have to comply with some of the provisions. The last thing that's really important is that even though the owner immediate family are exempt from some provisions, they still must comply with some very important WPS provisions. And we'll talk about those next. Next slide. So even on a farm covered by the owner immediate family exemption, the owner and immediate family are going to have to comply with all the following requirements. And probably one of the most important is that if they use a product that requires a respirator, they will still have to get the respirator training and medical evaluation fit testing required by the rule. So again, that's a key provision that is applicable to anyone that uses a pesticide that requires the respirator. They also have to provide and use the PPE listed on the label. They have to follow the RAI, meaning that they cannot allow family members into the field during an RAI except what's allowed under the exceptions. And they also have to make sure they follow the AZ requirements of not allowing anyone, including family members, to be in an AZ area during the application. Next slide. Now we're going to talk about the certified crop advisor exemption. And again, this is because we've received a lot of questions on it. There's been a lot of confusion, so we want to try and clear up some of that information. The first thing we want to talk about, next slide, are some key definitions that affect the certified crop advisor, just because the crop advisors have a sort of unique place in the WPS in terms of the activities that are allowed. So the first thing that's important to note is that a commercial pesticide handling establishment is defined as any enterprise other than an ag establishment that provides pesticide handler or crop advising services to ag establishments. And again, that's important because, as I mentioned earlier, we traditionally think of people covered by the WPS or those that are applying pesticides, either applying them for hire or applying them on the ag establishment themselves. But there are entities that are covered by this rule, covered by the WPS, that never apply a pesticide. So a crop advisor or a crop advising establishment that doesn't provide pesticide services can still be covered by the rule. A crop advisor means any person who is assessing pest numbers, damage, pesticide distribution, the status requirements of agricultural plants. So it's fairly broad. There's a lot of activities covered by the crop advisor definition. So if you're in there looking at, the health of the plant, if you're assessing what type of pest damage you have, if you're assessing whether it's at a certain bloom point, for making certain types of applications, or if you're assessing its, ability to be harvested, those things, all types of things that could be considered crop advising activities. Next slide. Another key definition is handler, and that's just because the very last part of the handler definition says a handler is somebody that is performing tasks as crop advisor during any pesticide application or RAI. So what that means is that when somebody is doing crop advising tasks during an RAI or a pesticide application, they are considered a handler under this rule. And that would mean that by doing that, they have to be provided handler protections, they would have to get handler training, and all of those things if they perform crop advisors that qualify them as a handler. So what it means as a crop advisor, depending on what they're doing, may have to be trained as a handler, equipped as a handler, and receive all the handler protections, or if they're doing something in another situation as a crop advisor, they may fall as a worker. Next slide. So another thing is, as I was mentioned, the definition of worker means any person, including a self-employed person who is self-employed and performs activities directly relating to the production of agricultural plants on an ag establishment. So most of the times we think of workers as somebody that is just doing harvesting, weeding, hoeing, and things like that. But as you can see, if you start doing crop advising tasks after the REI, then you are defined as a worker. You're still doing a crop advising task. It means that you're doing a crop advising activity, but because you're doing it after the REI or after application, you're now defined as a worker under the rule. And that means a crop advisor who only went into a field after the REI or after a pesticide application would only need to be receiving worker training and worker protections. And so it just goes to show you that depending on the activity they're engaged in and when they're doing it, a crop advisor may need to be trained and equipped as a handler or could potentially only need to be trained as a worker. Next slide. The last key definition is a definition of hand labor. As you are aware, as I mentioned earlier, hand labor is a group of activities that cannot be carried out during the REI because of the REI restrictions. But hand labor also says is that, you notice at the very end, it says that hand labor does not include operating, moving, or repairing irrigation or watering equipment or performing crop advisor tasks. And the reason that is important is those two things allow irrigation to be carried out during an REI, and otherwise it wouldn't be because it would be considered hand labor. And the same with crop advising tasks. Because we specifically define a crop advising task as not being hand labor, then it is permitted to occur during the REI, and that's important because early on in rural development, we were told by essentially agricultural production that if we did not allow crop advising and IPM and scouting to occur during the REI, it would shut agriculture down. So this is the way that we allowed those activities occur during the REI without them being prohibited. Next slide. So again, we've talked about all the different things that bring crop advisors under the WPS and how they're covered. Now I want to talk about essentially, and as we've already talked about, how they are covered in terms of who is going to be responsible for providing their protections. So crop advisors that are direct employees of agricultural establishments means you might work for a big establishment like Duda Sons employed directly. That means it is the employer or the owner of the agricultural establishments that's responsible for providing those crop advisor protections, that you are an employee of that establishment. The other way is that employees could be, crop advisors could be employees of commercial pesticide handling establishments, as we mentioned earlier, depending on the definition. If a commercial pesticide handling establishment is also providing crop advising services, they fall under that. So in that case, then it becomes the handler employer or the commercial pesticide handler employer that must provide the WPS protections. We also have situations like certified crop advisors or some entities where they work on their own, what we'd call a self-employed crop advisor. And then in that situation, it is the self-employed crop advisor that must self-provide the applicable WPS protections. Next slide. So we have an exemption for certified crop advisors, and certified crop advisors are different than regular crop advisors. Anybody can be a crop advisor. You don't have to have any education or any technical skill. You are a crop advisor just because of the nature of the activity you do. So Don or I can be a crop advisor. If I step out on that field and say I'm going to start assessing pest numbers, it depends on what I do and not my background or my role. It depends on what I'm hired to do and the task I'm doing. We also have what are called certified crop advisors. These are people that have passed a certified or licensed by a program accepted in writing by EPA states or tribes. This is a program that requires pesticide safety training that must include the same WPS training that's included for handlers in that program. And in order to be considered a certified crop advisor, they can only perform crop advising tasks while in the treated area during an REI. So these are all things that limit the exception. Next slide. One of the key elements of the exemption for certified croppers that changed with the new rule is that it is only the certified crop advisor themselves that are covered by the exemption. So it used to be under the old rule that a certified crop advisor and then anyone they employed under their supervision were covered, and that is no longer the case. So now only the certified crop advisor is covered by the exemption, but none of the employees that are not certified are covered. Next slide. One of the things we want to point out is that there are 2 national organizations that have met EPA's requirements for qualifying for the crop advisor exception, and so we've approved those to operate across the country, both nationally, and so they're covered, and so that if you encounter any people that are either employed or working as American Society of Agronomy Certified Crop Advisors, what we call CCAs, or if they're working as crop consultant under the National Alliance of Independent Crop Consultants Program, or NAICC, all of those members have been recognized as certified crop advisors that meet the exemption and so are qualified under the rule. Next slide. Just a real quick comparison. The difference then for what a certified crop advisor gets versus the uncertified is that the certified is exempt from some provisions. There is no exemption for the uncertified crop advisor. The crop advisor certified gets to self-determine the PPE during the REI. So depending on no matter what the REI may require the PPE for either a handler to wear during the REI or for early entry, the certified crop advisor can make their choice as to whether wear that PPE or not wear any at all. Because of their education experience, we've left it up to them to determine if the type of activity they're going to do is going to warrant an exposure and they should wear their PPE, or if they feel they can safely operate in an REI without wearing it because of the limited contact they're going to have. It's up to them as the expert to make that determination. An uncertified crop advisor does not have that choice. They will always have to wear the PPE when they are entering into an area under an REI. The crop advisor, the uncertified, must have the applicable pesticide safety training and protections for either worker or handler, depending on whether they're working after the REI or during. The certified crop advisor doesn't have to have the decontamination supplies or emergency assistance provided. But on the uncertified, they must be wearing the PPE. They must be provided the decontamination supplies appropriate for doing either handler or worker tasks, depending on when they're doing the crop advising tasks, and they also must be provided emergency exceptions. Last thing to point out on this is that there is a PPE exception for crop advisors, and we'll talk about that on the next webinar when we talk about some of the more detailed things on PPE and PPE exceptions. Next slide. And then lastly, this is just the thing that employers, if you're employing a crop advisor, this is what you're going to have to do as the employer. You have to provide the decontamination supplies. That's 1 gallon of water if they're doing a worker. If they're considered a worker crop advisor, if they're considered a handler crop advisor during the REI, then it must be 3 gallons. They must provide pesticide safety training. They must provide the PPE and care and maintenance for that crop advisor if they're going in and doing anything that requires PPE. And then lastly, they must provide the emergency assistance. And that's it. Back to you, Don.
Okay. Thank you, Richard. Sean, if you can advance, thank you very much. And now I'm going to address the hazard communication aspects. Next slide, please. All right, the general topics I'm going to cover are the central display, of course, that is composed of the safety poster. Going to talk about that a little bit, pesticide application information, and the hazard information, the safety data sheets. We'll also address the establishment-specific information that has to be relayed, notifying workers of treated areas, and information exchange between handler employers and agricultural employers. Next slide. Okay, employer responsibility. The employer must display, maintain, and provide access to the pesticide safety information. That's the safety poster we're talking about. And also have appropriate SDS sheets for all the pesticides that have been used. And of course, have to also post the application information. And all this is posted if workers or handlers are on the establishment and within the last 30 days the pesticide has been used or an REI has been in effect. This has to be centrally located, as in the former revision of the rule, and then readily visible and accessible. Next slide. Okay, safety poster, addressing that. At the beginning of this year now, the new safety poster is required, and there is an EPA version of that has been available through the PERC website, as everyone probably knows. And below in green are listed some of the changes to the new safety posting, new content. There's improved content, more content, adding a seek medical attention as soon as possible. If you're injured or made ill by pesticides, and the name, address, and phone number of the state or tribal regulatory agency. So if you're out there inspecting and you see the top picture there, That's the old safety poster. That's a violation now. Whereas to be in compliance, you have to have the new EPA safety poster, which is illustrated in the lower picture. Of course, the employers can also make up their own safety poster, in which case then it'd be a little more difficult because then you'd have to check that all the appropriate content is there. Next slide. Pesticide safety information, this has to be displayed also at the decontamination sites, at permanent decon sites as we put the safety poster up as well. And then also where decon supplies are provided at locations where we have 11 or more workers. Next slide. All right, we mentioned already the safety data sheets. There's a picture there of a folder. Should be an SDS available for every pesticide that's been used. Can, of course, be on a computer as long as all the workers have access to it and the password and everything and during the daytime normal work hours. And the application information, that should include the product name, reg number, the active ingredient, crop or site treated, location, description of treated areas, dates and times when the application started and ended, and the duration of the RAI. And the items in green, of course, are some of the new content now of the application records. Next slide. Okay, when must the pesticide application and hazard information be displayed? No later than 24 hours after the end of the application and remain up 30 days after the RAI ends, or at least until no workers or handlers on their establishment, whichever is earlier. For ag employer to ensure that workers do not enter the treated area until the application information and SDSs are actually displayed, and then RAI has expired, and all warning signs have been removed or at least covered up. So workers cannot get in there until you cover up those signs or remove them. Next slide. Okay, record keeping, as you already know, and was mentioned now, there's a record keeping component to this. So the ag employer must retain on the ag establishment the records, application records, and the SDSs for 2 years after the RAI expires. Next slide. And then how can a worker handler have access? Of course, they can go and look at it. It's centrally located while it's displayed. Workers or handlers can also request copies and access to it either in writing or orally, and the ag employer must provide that within 15 days. Treating medical personnel can also request copies, and the ag employer must provide that promptly to the treating medical personnel. And of course, we have this designated representative who can request it of the ag employer. That has to be requested only in writing, and there is specific content in that request. And then, of course, the ag employer has to provide that within 15 days. Next slide. All right, for inspectors evaluating central display, central location, obviously just observe what's there and make note. Maybe take photographs, look for the safety poster, appropriate one, the new one. Safety data sheets, are all the safety data sheets appropriate for every pesticide that's logged in or the application record. And then also look for the safety poster at the permanent decon sites. And then even conduct employer interviews, ask them some general questions about when is the information amended, when is it put up, where is the old 2-year records if it's not posted anymore. So those are some of the things that an inspector can ask. Next slide. And of course, one should also interview workers and handlers according to the WPS inspection, the older guidance as well as the new inspection manual. There should be made an attempt to interview at least one worker and one handler as part of a WPS inspection. And then we have in the manual various questions that one could ask of either, such as, do you know where the pesticide safety information is? Where is the emergency medical information located? How would you find the SDS? And how could you obtain a copy? So those are just sample questions. There are many more in the inspection manual. Next slide. Okay, and notification. The idea here, of course, is to keep workers out of treated areas during the RAI. Ag employer must notify workers about applications and entry restrictions unless, this is where notification is not needed, the worker will not enter in, work in, or pass through within a quarter mile of the treated area, and the worker will not enter any part of the enclosed structure. Otherwise, notifications have to be provided orally or by signs, or might be double notification if it's labeled as such on the label. And then I'll talk about the minimum hours required posting too. Next slide. All right, as mentioned, Richard mentioned this too. For some labels, there's required double notification that will be on the label, so the workers have to be notified both through signed postings and orally. And then there's also posting warning signs are required if the RI is greater than 48 hours for outdoor production. Make note, this is not on the label per se. And then posting warning signs is required if the REI is greater than 4 hours for enclosed space production. If not any of these, then otherwise, then the employer has the option of warning workers orally or by posting signs. Next slide. Okay, oral notification must be provided in a manner that workers can understand before the application or at the beginning of the first work period. And of course, it has to include location, description, and treated area, time during which entry is restricted, and instructions not to enter the treated area or application exclusion zone. Next slide. Posting of signs must be posted prior to, but not earlier than 24 hours before the application. Again, this is no change from the other earlier version in the WPS. And the signs must be removed or covered within 3 days. And of course, if the sign is not covered, then workers are not allowed in unless, early entry provisions. So really the sign itself has not changed from before. Next slide. Posting location, signs must be visible from all reasonably expected points of worker entry. This may include each access road, each border with any worker housing area within 100 feet of the treated area, each footpath or other walking route that enters the treated area, and if none of the above, then at least in the corners of the treated area where they afford maximum visibility. Next slide. Okay, some inspection considerations for the notification. Of course, direct observation, not just the office visit, but it's getting out in the fields, what's been treated, what's not. And of course, you can check at the application board to see what fields are still under the REI or not, and observing warning signs or asking about oral notifications. Also conducting the employer interviews, like ask questions. And again, there are many more than just indicated here in the inspection manual. You could ask the employer, how did you notify workers about recent applications? When, what, how? Do you communicate the information? How does the employer ensure that workers don't enter the treated areas? And then, of course, you could conduct the worker interviews as well and ask them related questions. Next slide. Okay, information exchange. This unfortunately is still kind of a big issue in quite a few states. Both ag employers and commercial pesticide handler employers are responsible for relaying information about pesticide applications to each other. And in turn, each of those employers are responsible for notifying and providing protections to their own employees. So next slide. Information exchange for ag employer. The ag employer must ensure that if handlers are employed by a commercial pesticide handling establishment, and they're going to be on that establishment, the handler employers provide information about the specific location, description of the treated area, in which they might be within a quarter mile of, and any other restrictions to the area. Next slide. The commercial pesticide handler employer, before the application of any pesticide, the commercial pesticide handler employer must provide the following information to any ag employer. Again, the specific location and description of treated area, start and estimated end times, and the date of the application, the product name, EPA registration number, active ingredient, REI, whether posting, oral, or both are required according to the label, and any other label protections. Next slide. Key changes here before the application. If any pesticide in an ag establishment, provide the ag employer, again, those details, including the start and estimated end times of the application. That's relatively new now. Provide certain updating information prior to the application. Provide changes to estimated end time, and product name within 2 hours of completing the application. And if there are any changes to the estimated end time, if it's only less than 1 hour, then the commercial handler employer need not provide that to the ag employer. Next slide. Okay, information exchange. How would inspectors kind of verify that? Of course, employing an interview with the ag employer. Do you hire commercial applicators, and what kind of method has he arranged with the commercial applicator in terms of the notification? They should have some kind of plan in place and some way by which they communicate to each other whenever applications are made. You could also interview the commercial pesticide handler employer. So not just the ag employer, but the person he hires. And again, ask some of the same questions. What communications do you have with the ag employer before the application? How do you provide that information? How and when are changes relayed? And then one could also interview the handler themselves. Is he being informed by his supervisor? Next slide. All right, coming up next, who, what, where, and the measures of mitigation by Carol.
Thanks, Don. I'm going to talk briefly about mitigation measures that are required in the Worker Protection Standard. Next slide. Okay, who has to provide decontamination supplies? Well, whoever employs the worker has to provide those, or whoever employs the handler needs to provide those decontamination supplies. It's pretty straightforward. Next slide. What supplies have to be provided? Soap, single-use towels, water, and a clean change of clothes for handlers. So how much water is needed? It has to be sufficient to do the job. Now the regs say that it has to be 1 gallon per worker and 3 gallons per handler, an early entry worker, at the beginning of their work period. But obviously it's not going to be okay if 2 hours into the work shift all the decontamination water is gone. The employers will need to replenish those water supplies so it's still available and sufficient should there be a need for decontamination. Next slide. Continuing talking about the water, where does the water come from is a good question to ask, because it can't be the same water source that's used for mixing unless there's equipment that prevents contamination. The water has to be a good enough quality and temperature so it doesn't harm the person. It doesn't need to meet drinking water standards, but it has to be a reasonable temperature and quality. In an emergency, it's okay to use natural waters if it's easier to reach those than the decontamination water. Next slide. Where are the decontamination supplies located for workers? Well, they have to be accessible. They have to be located together and outside, excuse me, outside of the treated area or the area under an REI. They have to be within 1/4 mile of the workers or at the nearest place you can get a vehicle if that's more than 1/4 mile away. And for handlers, the decontamination supplies must be located where they remove their PPE so they can wash, and at any mixing and unloading sites. Next slide. So when and how long do you provide decontamination supplies for workers? Well, it needs to be from the time the workers enter the treated area until 7 days after the REI expires, if the REI is more than or equal to 4 hours. I'm sorry, it's 4 hours or less, or 30 days after the REI expires if the REI is more than 4 hours. And for handlers, the decontamination supplies must be available whenever the handler is doing his handler tasks, his or her, and they must be available again where they are changing out of their PPE. Next slide. Okay, if there's a need to have emergency eye flush, who has to provide that? Again, for handlers, it's either the ag employer or the commercial handler employer. For early entry workers, it's got to be provided by the ag employer. Next slide. And what can you use? What do you use for the eye flush? It has to be a system that can deliver a gentle flow, like 0.4 gallons for at least 15 minutes, or at least 6 gallons of water that can be used to provide a gentle flow of water for about 15 minutes. And any of these options that you can see there would meet that need. So they can use different approaches if they want to. And again, the eye flush is required at each mixing and loading site. It's not based on per handler. You don't have to have several. You just have to have a emergency eye flush facility. Next slide. Okay, where and when do you have to provide that? Well, you can ask, do you use a product that requires eye protection? Do you use a closed system under pressure? In that case, you have to have an emergency eye flush. So you can ask, where is that? Do you have it? What is it composed of? And again, it's got to be immediately available at each mixing and loading site, and there has to be a pint of water immediately available to each applicator and early entry worker if they're using a product that requires eye protection. So it's got to be reachable in case they need it. It's got to be very close, if not on their person. Okay, next slide. Then who's responsible for providing emergency assistance? Again, it's the employers of the pesticide handler, either the commercial or the ag employer. And what does that look like? The next slide. You can ask, have you ever had a pesticide exposure incident here? If someone has reason to believe that a worker or handler has experienced pesticide exposure or they show symptoms, you can ask about that. And how did you handle that? If either of those situations have occurred, the employer needs to provide transportation to a medical facility capable of providing the needed care. And they need to provide information to the treating personnel, including the name of the pesticide product and how the incident happened. Okay, that wraps up mitigation measures, and it's back to Donald.
Okay, thank you very much, Carol. Now I'd like to address safety training, pesticide safety training under the WPS. Next slide, please. Okay, trainers and workers and handlers. Most of you all know this already, but you have to be a certified under RUP applicator of RUPs, and that could be any category. Have completed an EPA-approved pesticide safety trainer program, or be designated by EPA or the state agency in order to train. Next slide. Okay, training requirements. Used to be a grace period. There's no grace period any longer, as you already know, and training is required annually. Training methods, the area must be reasonably free from distraction. The trainer must be present during the entire thing, and then the training must use EPA-approved materials. Next slide. Okay, evaluating worker or handler training. The inspection manual, pages 27, 54, and 61 cover this. Again, there are a lot of sample questions, more than we can actually go through here. But you can ask workers and handlers if they received this safety training, and then when did they get it, if it was in the last 12 months. You can ask the employer whether they do the training, who does the training, what kind of materials they use, and verify whether that's EPA approved or not. And then, ask even the employer if someone was hired to do the training. They don't have to do it necessarily themselves, the ag employer. Next slide. Some notable changes. Handlers who have not taken the trainer course are no longer qualified to provide the training to workers. Train-the-trainer courses must be EPA approved, and there is an EPA process along with a document that came out actually about a year and a half ago for this whole process. All training materials as well as trainer courses are submitted to headquarters, OPP, and then they're also shared with the respective region where they originate from to receive their approvals. And then completion of any EPA-approved trainer courses qualifies a person to train in any location state unless the state prohibits that. Next slide. Okay, training content, of course, has changed quite a bit. For workers, used to be 11 points. The revised WPS now contains 23 points, and handlers now is increased from 13 to 36 points as far as the content of the training, pesticide safety training for each. As you already know, the new expanded training requirements, though, are not required right now, so they can be trained under the old system with the old content or the new content. And the new content doesn't necessarily kick in until EPA publishes notice of availability of the training materials, and the EPA does not intend to do that, at least for this year, 2018. So currently, training in either old or new content is allowable. Okay, next slide. All right, exemptions required to handler safety training, and the certified applicators in any category are exempt. Certified crop advisors, and Richard covered a lot of that about crop advisors already, who are licensed by an EPA or state of knowledge program, and then workers already trained as handlers. So if you already have handler training and you're doing then worker tasks, you don't need separate worker training necessarily. Next slide. Okay, as far as record keeping, we didn't have that previously, but this helps tremendously for you, the inspectors, to verify the training. So now it's required that the content of the worker handler has the printed name, the signature, the ag employer name, the date of the training, kind of EPA materials, EPA approved materials used, the trainer's name and trainer qualifications. And as mentioned, this is also a 2-year retention, just like the central posting information. And then the employer must provide a copy of those records on request to handlers or workers. And the WPS inspection manual covers this, and some of the recommendations there are to review and copy or photocopy all the training records, and then ask the employer what happens. Has he been asked for those records, and how would he respond to that request? Next slide. All right, next up is Richard Pond again, talking about other employer responsibilities. Take it away, Richard. I'm not sure where Richard is. Okay, who must comply? All types of employers must comply with the requirements discussed before, ag employers of workers or handlers or commercial pesticide employers. Next slide. Employers must ensure that any pesticide used in a manner consistent with the product labeling when applied on the ag establishment. Employers must ensure that each worker or handler receives the WPS protections and ensure that equipment for mixing, loading, and transferring or applying pesticides is inspected and damaged equipment is repaired or replaced before each day use. Next slide. Go ahead, Richard,
Yep.
then. Okay.
Thanks. Sorry about that. Technical problems, but the two things that, again, are probably most important in terms of the employer's responsibility is to make sure that they provide information and directions to the supervisors and labor contractors, as well as specifying who's responsible. And that's the key as you get into this of who was responsible. We'll talk about that. There has to be clear that the employer has, if he's relying on somebody else to carry out WPS responsibilities, that he's made that clear and made sure whoever he's assigned those responsibilities to, what they have to do in order to comply with the WPS and what those people have to do to instruct workers and handlers to comply. Next slide. Other key provisions that I want to point out is that the rule does contain an anti-retaliation provision that prohibits retaliation. This was expanded under the old rule. It just basically said, you can't retaliate if they're trying to comply. We worked with the Department of Labor to sort of mirror theirs, and now it covers they can't retaliate if the worker gets, does anything like, submits to inspection, gets involved in any type of, in case you want to interview workers. So anything like that where they're involved in inspection or interview or post-inspection type of thing, they can't be retaliated for involvement in that. Another key provision is the reference to 14B, which says that a person is liable for a penalty under FIFRA if another person employed by or acting for that person commits a violation. And the reason this is important is because the WPS has been fraught with lots of situations where the employer says, oh, well, no, I assigned that to a labor contractor. The labor contractor was responsible, not me. And what this points out is that FIFRA allows that no matter, whether they assign responsibility, hired somebody else to do it, they are always liable if a violation of the WPS occurs. And the other key thing that I want to point out here is when we're talking about hiring labor contractors, especially under the rule, labor contractors are not a responsible party for compliance with the rule. It's always the employer, either the agricultural employer, the commercial pesticide employer, the commercial handler employer, or the self-employed person. But labor contractors under the WPS are generally not held responsible. Again, doesn't mean that they can't be assigned responsibility to somebody, but inherently the WPS assigns responsibilities to the employer. Next slide. So there's a WPS internal policy out there that from the previous rule that is still both important and applicable here, and it essentially says that when looking at responsibilities for WPS enforcement actions, because if somebody has not complied, who would you look at as the most responsible party in terms of either employer, an owner, up the line? Next slide. So we've asked states to use the following 10 factors, and those are essentially, probably one of the most important is who has control over the pesticide use? Who is the person that is making the decisions about what pesticides apply and where to apply and how to apply them, and who directs that pesticide use? Because those are ultimately the people that are going to be the ones that have the chief responsibility for WPS compliance, because they're the ones that are aware of the pesticide labeling requirements and how they're being used and where they're being used and how that impacts the worker protection requirements. Other factors are who has control over the agricultural establishment for posting and WPS related responsibilities. Just like there's somebody that's actually applying the pesticide and has control of pesticide, that might be a commercial pesticide handler or something. But on the establishment, then you've got somebody who's actually responsible for the things on the establishment beyond the application. Again, that's why it's important when you have situations where you have commercial applicators involved in the application, identifying who was responsible for the particular part of the application that might result in the violation. Other factor, who gives direction on the ag establishment for posting and other WPS related responsibilities. And then last, who has control over the practices used by workers on the establishment. Next slide. The remaining 5 factors, who directs the practices used by agricultural workers on the establishment, measures taken to comply with provisions of the WPS, actions taken in response to incidents of noncompliance, history of prior violations, and the ability to assure continuing compliance. So those are the 10 factors that should always be used, and more often than not, if you apply these, it's easy to kind of work yourself down to who the most responsible party was for ensuring WPS compliance in any given situation. Next slide. Last thing we want to mention is the existing WPS Interpretive Policy 16-3. The reason this is important is it just pulls in the previous information we talked about, the FIFRA requirement that says an employer is responsible for anyone that they hire. And so essentially what this says is when you're looking at a incident of an establishment and who is responsible, the WPS is structured that we can hold not only the direct farm manager or a crew leader responsible, but we could go all the way up to the chain in terms of if it was at a university, all the way up to deans or somebody that would technically be in charge of that farm manager and that research farm. In the case of agricultural operations, a good example is an entity like Syngenta that owns multiple research farms and nurseries across the country. By and large, you might look at the individual research farm as the one that is responsible for what goes on in that establishment, and you would look at that farm manager. But if we found a pattern of non-compliance across all of Syngenta's farms, rather than going after an individual farm manager on one establishment, the decision might be to go after Syngenta or farther up the corporate ladder, because of the nature that they haven't made sure that each of their individual entities have carried out WPS responsibilities. And that goes back to what we talked about earlier, of the importance of the owner or the employer for ensuring that anyone they hire has complete instructions about what to do, because ultimately the WPS allows us to go back to any entity that might have responsibility for that particular establishment. Last slide. And then lastly, on minimum age requirements, we just want to mention, Carol already talked about how we're going to move forward. These requirements are in effect, even though we are considering changes to them this time. We might not ever make changes, or who knows which direction. So in the interim, the minimum age requirements are in effect, and those can be found at for ag employers and commercial handlers. They're the ones responsible for ensuring the minimum age of handlers or workers on their establishments. And then of course, remember, lastly, the minimum age requirements do not apply to owners and their immediate family members. Back to you, Don.
So here's my contact information. Please take a moment, jot it down. So you can reach me if you're having trouble getting a certificate or otherwise. And alternatively, of course, you can contact your own state WPS specialist in order to reach me. At this time, I would like to open up the training webinar to the questions from you. Again, a few questions have been submitted, and certainly we're open to take more questions. Right now, please identify at the top of your question what state you're from. The audio lines, of course, will not be open for any verbal questions due to possible disturbing background noises. I will be moderating the responses to the questions, and I'll read the question and ask the trainers to respond. And as I mentioned, we may not be able to immediately provide answers to all of these today, because some responses may require WICA management or legal counsel for final determination. And we may not have time to respond to all the questions. But before we open up to your questions now, we have received prepared questions in advance, as I had requested from all Region 5 states. Michigan and Wisconsin had provided several, so we're going to go through some of those questions at this point in time with some of the prepared answers to those questions. And then I've taken delivery too of preparing some questions that I've received from other Region 5 states in the last 6 months. So those are included here. So we can have the next slide, please. All right, going through some of the questions quickly. Again, these all came from state inspectors or from their state WPS coordinator. This one's from Wisconsin. It has to do with applications in forest, and there were quite a few issues up there in Wisconsin on this. Wildlife specialists apply pesticides to manage plant trees to improve the wildlife habitat. Does the WPS apply to this situation? And Richard kind of alluded to some of this earlier on. And the answer is no, the WPS does not apply to this situation because the crop is not for commercial production. Next slide. Okay, when does production trigger the WPS provisions? This is from Wisconsin as well. Strawberry grower sprays a fallow area with glyphosate to kill the weeds, and the field is later plowed under so workers can't plant the strawberry plants. Is this covered? by WPS? The answer is yes. The ground prep is considered part of the production, and so all WPS provisions are applicable as long as WPS label products are used to kill the weed. Because remember, that WPS doesn't kick in unless you're using a product that has the WPS reference statement on it. Next slide. Okay, is a field counter considered a worker? So in this case, the strawberry grower employs a person who will work with strawberry pickers. She counts the buckets and is in the area where the pickers are, but she doesn't actually pick. So again, as Richard pointed out, it kind of depends in part whether the definition of worker handler and the actually tasks they do. Does WPS apply to her? The answer here is no. This person is not performing hand labor and will not have any contact with the treated plants. The WPS does not apply to her unless she starts picking or has contact with a treated plant. All right, next slide. All right, another Wisconsin question has to do with orchards. Entrance to an apple orchard is within a quarter mile of the bathroom at a main farm building. However, the orchard extends another half mile beyond that entrance. Many of the orchards up there are fenced in to keep out the deer, I presume, from feeding on the fruits and on the orchard. Should a portable decon supplies be placed at the orchard entrance if that is the nearest access point? Now, the answer, of course, is decon supplies need to be outside of the treated area, but accessible within a quarter mile, or at least, as Carol had mentioned, at the nearest point of vehicle access. Decon supplies cannot be outside of the fenced-in workers. So in other words, you can't have the workers inside the fence area and put the decon outside of that fence because obviously it won't be accessible to them. Next slide. Okay, another decontamination from Wisconsin, how to keep decon water from freezing in the wintertime. So in some cases, it looks like timber is harvested during the winter, and perhaps a WPS product may be applied legally according to the label. So the WPS does not apply, obviously, if pesticides have been used within the last 30 days. If, however, applications are made in the winter legally with the WPS label product, then WPS provisions do apply. Water cannot be frozen, has to be of a quality and temperature to not cause injury or illness. It must be liquid. So they're going to have to figure that out, how to keep it liquid. Next question. Application forest from Wisconsin, pesticides are applied to a county forest, state forest, etc., with the intent to harvest the trees later in the year. Does it apply? The answer is yes. The WPS does apply to the situation because the crop will be sold commercially. Next question. Pesticide businesses hired to spray for invasive plant control in a county forest natural area. Does it apply? And we're not talking about commercial production here, so no, the WPS does not apply to the situation because the forest or natural area is not under the commercial production. Next slide. Electronic communications. This is often a common question. This comes from recently from Michigan. With electronic communications common, can oral notification be done using a recording device that would state what areas are treated? Could it also be done by a telephone message or through a text? The answer to this is no. Text messages or voice messages left on a phone can be used in addition to the oral notification, but not in place of. But it's not a substitute for direct oral notification. The intent of the rule provides that oral be verbal and direct to the worker. Text messages are not oral by definition. Next slide. Okay, posted notifications. This is from Minnesota of restrictions. Has to do with field warning signs. The nursery has a mix of workers who speak Spanish and some who speak Karen, which is from Burma or Thailand. The employer has created a field warning sign as you show in the picture here. It actually contains 3 languages, so English, Spanish, and Karen. And is that a violation? And of course, the answer is yes. This is a violation of WPS. The WPS only permits 2 languages in the sign, English and another language, to replace Spanish for the majority of the workforce. WPS does not allow 3 actual languages. However, this deviation does meet the intent of the rule to warn workers regardless of the language. Richard just went over the WPS IGW Q&A 16.1 in terms of appropriate enforcement action and considerations by the state. And additionally, states have the prosecutorial discretion regarding enforcement. Next question. Field warning signs. This is from Minnesota as well. Nursery has now affixed their warning signs to highway cones for ease of placement and storage stacking when not in use. Is this a violation? And the answer is no. As long as the sign on the cone meets design and text requirements, the cone satisfies the spirit and intent of the regulations. The wraparound sign cannot overlap any text, and it cannot be obscured by any vegetation. In general, people will see the orange cone as a signal to be careful and that there is danger here. There's enough warning language visible on the sides of the cone to relay the intended information from many directions. So again, there's an example there of the innovative thing that nursery has come up with in terms of the field warning sign. Next question. Okay, multiple owners who are not related. This actually came from a while back from Ohio. Previous IGW 2015, this is the older one, seems to disagree. This is what the Ohio question was, to disagree with the how to comply manual with regards to multiple owners. Richard already kind of addressed that it has changed. The older IGW says that in the case none of the owners qualify for the family exemption, while the how to comply states otherwise, the family exemption applies. So the rule, as was mentioned by Richard, has changed in 2015, so that old IGW for multiple owners is not correct any longer. The family exemption applies to all owners and their family, even if they're unrelated, as long as one owner has majority of the ownership, majority again being greater than 50%. And that page 88, the How to Comply manual, also talks about this. If, however, no family owns greater than 50%, then the family exemption doesn't apply to anyone. Next question. Training qualifications from Wisconsin. The person is not a certified applicator, but took a state train-to-trainer course prior to the revision of the rule. Do they need to retake the new EPA-approved train-to-trainer course to train under the new content? And of course, the answer is yes. The WPS now requires that a train-to-trainer takes an EPA-approved course in order to train other trainers or workers. There's no expiration date for this, however, and there's no requirement that they retake the course later. Next slide. Okay, what is immediately available? Greenhouse grower mixes at various locations within the greenhouse. Can eyewash be further away in the greenhouse? And what is immediately available? This is a question that's kind of popped up over and over many years. The eyewash, as Carol had mentioned, has to be 6 gallons or flow of 0.4 gallons per minute for 15 minutes at each mixed load site, and it must be immediately available. And this immediately available means the eye flush is at the site or otherwise close by where it can be obtained in seconds. So you can't have the mixed load at one end and the eye flush at the other end of the greenhouse, in other words. Next slide. From Minnesota, it's seed treatment. There are some labels out there with the ag use box and WPS reference statement on some seed treatment labels, but not others. And the question is why? Well, some of the products are labeled for seed treatment at an ag establishment or at the time of planting fall under the scope and so have the WPS reference statement, because applications to seeds just before planting is considered an application. Other products, however, that only allow seed treatment at the commercial treatment facility, and therefore they're not covered by the WPS, and they then will not have the WPS reference statement on those particular product labels. Okay, multiple owners who are not related. This actually came from a while back from Ohio. Previous IGW 2015, this is the older one, seems to disagree. This is what the Ohio question was, to disagree with the how to comply manual with regards to multiple owners. Richard already kind of addressed that it has changed. The older IGW says that in the case none of the owners qualify for the family exemption, while the how to comply states otherwise, the family exemption applies. So the rule, as was mentioned by Richard, has changed in 2015, so that old IGW for multiple owners is not correct any longer. The family exemption applies to all owners and their family, even if they're unrelated, as long as one owner has majority of the ownership, majority again being greater than 50%. And that page 88, the How to Comply manual, also talks about this. If, however, no family owns greater than 50%, then the family exemption doesn't apply to anyone. Next question. Training qualifications from Wisconsin. The person is not a certified applicator, but took a state train-to-trainer course prior to the revision of the rule. Do they need to retake the new EPA-approved train-to-trainer course to train under the new content? And of course, the answer is yes. The WPS now requires that a train-to-trainer takes an EPA-approved course in order to train other trainers or workers. There's no expiration date for this, however, and there's no requirement that they retake the course later. Next slide. What is immediately available? Greenhouse grower mixes at various locations within the greenhouse. Can eyewash be further away in the greenhouse? And what is immediately available? This is a question that's kind of popped up over and over many years. The eyewash, as Carol had mentioned, has to be 6 gallons or flow of 0.4 gallons per minute for 15 minutes at each mixed load site, and it must be immediately available. And this immediately available means iFlush is at the site or otherwise close by where it can be obtained in seconds. So you can't have the mixed fluid at one end and the iFlush at the other end of the greenhouse, in other words. Next slide. From Minnesota, it's seed treatment. There are some labels out there with the ag use box and WPS reference statement on some seed treatment labels, but not others. And the question is why? Well, some of the products are labeled for seed treatment at an ag establishment or at the time of planting fall under the scope and so have the WPS reference statement because applications to seeds just before planting is considered an application. Other products, however, that only allow seed treatment at the commercial treatment facility, and therefore they're not covered by the WPS, and they then will not have the WPS reference statement on those particular product labels. Next question. Okay, from Indiana, again, another text thing came a few months ago. Can a seed grower notify his detasseling crew who enter a treated field by text in place of oral notification with the required notification text back? And you all probably know the answer to this. Now the answer is no. The WPS is specific in that oral notification or signposting are the only notification options. Text is not oral. Text cannot be used as a notification alone, even if detasselers have a company phone and all texts are confirmed by return receipt. Text can be used in addition to oral notification, but not as a replacement. The problem with text, of course, is, Wi-Fi reception may be poor, especially out in the fields. The workers may not hear them or even respond immediately. Next slide. All right, I think that pretty much concludes, and those are all the various questions that Michigan and Wisconsin said in applicable to this part 1. There are some others applicable to AZ, which we're going to address in part 2. And then again, those are some of the state questions that I've received in the last 6 months from other Region 5 states.
This concludes today's EPA Region 5 Advanced Worker Protection Standard Inspector Training, Part 1. I would like to thank our trainers, Richard Pont and Carol Galloway, who have graciously given much of their time and expertise to contribute to this training. We also are very grateful to the EPA Center for IPM, Shonda Bennett and Brad Miller, for all the logistical assistance. Tom Cook and Frank Ellis of the Center provided approval for their resources to support this webinar. If you have questions about the WPS, please direct these to your EPA Regional WPS Specialist or to your state WPS Coordinator. Thank you for taking this training to improve your inspections for WPS compliance.